Good afternoon, members of the media. I'm pleased to present on a bill recently tabled in the Senate entitled the Municipalities Amendment No. 2 Act 2015. Before going into the details of the bill, it is important that I lay out some very important background that led the government of Bermuda to take this consequential step. Many of you will be aware of significant challenges posed by the municipal corporations in recent years under both the current and previous governments. Reform of local governance has become acutely necessary in Bermuda as a result of failures of administration that have caused disarray in governance. However, let me make something absolutely clear. The failures are entirely because of actions of the Corporation of Hamilton and not St. George's. This drive for reforms has seen extensive amendments to the Municipalities Act 1923 in 2010, the Municipalities Reform Act 2013, and various amendments approved during the previous and current legislative sessions. Further governance reform is now acutely necessary as a result of failures of accountability in awarding of the contract for the Hamilton waterfront development, resulting in a highly critical report by the Bermuda Ombudsman, legislative intervention by the Governor of Bermuda, the assumption of temporary stewardship, and an arbitration that may cost millions of dollars to the public purse. Concerns about the viability of a cooperative relationship between the two levels of government during the America's Cup. The multiplicity of legal actions such as the clamping litigation and a myriad of constitutional actions. Disorder and dissension at the council level that have been reported in the media, which led to the implementation of the current stewardship order. Inadequate resources to undertake important public infrastructure projects such as the needed upgrade to the sewage system. And recent media reports of a corporation-backed loan of $18 million that had potentially gone sour and which has led to legal difficulties, which I will deal with in due course. Many of these failures and concerns, amongst others, led to action by the Ministry with the approval of Cabinet in late 2013 to temporarily assume stewardship of the Corporation of Hamilton's financial administration and treasury functions. During this period, a new set of financial instructions and a meeting guide were prepared for the corporation, and stewardship for the corporation was returned in March of 2014. After the financial and treasury functions were returned to the Corporation of Hamilton, the government, the mayor, and other members of the corporation set about to try and cultivate a relationship marked by dialogue and collaboration and turn a page on past acrimony and recriminations. I was quite pleased with the progress made throughout the latter part of 2014 and the constructive dialogue we engaged in. This calm was shattered in December last year when the ministry received news that, yet again, it would be the target of court action by the corporation. The background to this action was recently described by the Chief Justice as, quote, somewhat murky, unquote, and arose in circumstances leading to the government to challenge the authorization of attorneys purporting to act for the corporation. I am pleased that our position was subsequently vindicated by the courts. There then appeared in January 2015 an irreparable rupture between members of the corporation, leading to a vacuum in leadership. This, together with the government's concern with what appeared to be a disregard for taxpayers' dollars in pursuing litigation, and concerns over the council's decisions in regards to the exposure of corporation property in respect of the potential development at the Parlerville car park, led to the issuing of a second stewardship notice relating to governance functions on 26 January 2015. I then took over the affairs of the corporation as steward, so as to fill the vacuum left by a bitterly divided council. I am pleased to say that the Chief Justice ruled in favor of the minister being able to assume stewardship of the corporate governance function, of the governance functions of the corporation in circumstances where those functions have broken down. The people of Bermuda need to be made aware that the corporation has spent many hundreds of thousands of dollars in litigation, what Chief Justice Ian Caverly has termed the corporation's ultimately futile impasse between itself and the central government. Such realities cannot be ignored. Despite all of this, I recently had a meeting with some members of the council so that a common understanding can be found between all as the current administration term comes to a close. I believe that there can be some common ground found in the remaining weeks. Despite the improvements to governance made in the Municipalities Reform Act 2013 and recent amendments in this legislative session and the last, it is obvious that we are only part of the way through the reform process. There are a number of major items which still need to be addressed, and the Municipalities Amendment No. 2 Act 2015 is an important part of this. The bill, in summary, strengthens the oversight by government of the affairs of the corporations. The first important reform would be to allow the minister to provide binding directions to the corporations. These are similar to those provided for in legislation relating to the West End Development Corporation and the Bermuda Land Development Corporation, permitting general and special directions from their respective ministers. The bill would further permit the minister to appoint a public officer as his delegated representative to, among other things, attend meetings of a corporation. The appointment would facilitate communications between the corporations and the ministry. The bill would also allow the minister to delegate functions to any employee or officer of a corporation which is under the minister's control or stewardship in order to oversee the efficient execution of its day-to-day affairs. The minister would be required to support any resolution or ordinance passed by a corporation either personally or by way of his ex officio appointment. Finally, the bill would improve the current law on temporary stewardship in order to bring greater clarity and to immunize them from future legal attack. While we are pleased with the Chief Justice's recent ruling clarifying the extent of the stewardship provisions already presently within the Municipalities Act, the legislation seeks to make clear that the minister can take over the financial and/or full governance functions of a corporation where it is being mismanaged or where its financial or general functions are otherwise in a poor state. What I've detailed already clearly demonstrates that these reforms are essential to ensure we have a properly functioning municipalities in Bermuda. Let me be absolutely clear. I do not want to play an active role in the affairs of the corporations. I've been plenty busy given the other responsibilities I have as the Minister of Home Affairs and as part of a government elected to turn around the economy and the myriad of problems that were inherited in December 2012. However, the events of recent years and months have forced the government's hands. We did not go down the path of abolishing the corporations, which was something considered by the previous administration. We considered that Hamilton and St. George's have played an important role in the history of Bermuda. In fact, we have given more funding to both by returning wharfage, and in the case of St. George's, establishing a heritage fund. Furthermore, it is my hope and expectation that the forthcoming elections will usher in an era of mutual cooperation for the benefit of residents and businesses in the town and city and the wider community, no matter who is elected. The bill is not aimed at any one group or individual, despite efforts to paint it as such. In an ideal situation, these powers will fall away and become largely pro forma. We may even be able to contemplate future legislation where these restrictions are removed and an entirely new act is drafted that reflects a separation of powers in a modern age. However, we would be remiss if, in response to recent challenges, government chose not to act. In fact, it is important that the national agenda and the agenda of any council are aligned in some way to ensure there is harmony in Bermuda's governmental functions, especially given that the city and the town are major parts of Bermuda's economic lifeblood. Cooperation is key, and the government of Bermuda is committed to that, no matter who ends up as the mayors and councillors of the city and the town. With that said, now I will turn to a very recent event in respect of the Parleville car park. In summary, you will recall that under the Municipalities Act 1923, the Corporation of Hamilton has the power to utilize its property to secure loans up to the amount of $20 million. In accordance with this power, the Council of the Corporation of Hamilton passed a resolution in July 2014 and issued a mortgage to Mexico Infrastructure Finance, LLC, over the Parleville car park to secure the Corporation of Hamilton's guarantee of a debt to Mexico Infrastructure Finance, LLC, of $18 million incurred by Parleville Hotel and Residences Limited. That's the company that has entered into a ground lease and development agreement with the Corporation of Hamilton over the Parleville car park to develop a hotel and residences. The intent, as far as I can gather, is that the debt of $18 million, which was in fact a bridging loan given by Mexico Infrastructure Finance, LLC to Parleville Hotel and Residences Limited, was to secure financing for the hotel development. The bridging loan was to be repaid by Parleville Hotel and Residences Limited by the end of December 2014. Sadly, that loan has not been repaid by Parleyville Hotel and Residences Limited to Mexico Infrastructure Finance, LLC, in accordance with the terms of the various agreements. And as such, Mexico Infrastructure Finance, LLC, has exercised their rights under the various agreements to appoint joint receivers over the Parleyville car park to begin recouping the $18 million debt. It appears that a substantial sum of the bridging loan was at some point paid to a company registered in Gibraltar called Argyle Limited as a fee to get access to a large line of credit to develop the financing for the hotel and residences development. Both the corporation, me as steward, and the mortgage holder are doing everything possible to obtain further details as to the whereabouts of the bridging loan money. Today, I, my acting permanent secretary, the secretary and treasurer of the Corporation of Hamilton, and our legal advisors met with representatives from KPMG and lawyers representing the holder of the mortgage interest over the Parleyville car park. At that meeting, we were advised that Mr. Mike Morrison and Mr. Charles Thresh of KPMG were accordingly appointed by the mortgage holder on 31st of March 2015 as joint receivers. In practice, this means that the Corporation of Hamilton will still operate the Parleyville car park, but income collected will be turned over to the joint receivers to pay down the debt owed by Parleyville Hotel and Residences Limited. In practice, the public will notice no difference in respect of the operation of the car park. The receivers and the Corporation of Hamilton are working with Easy Park and other stakeholders as appropriate to ensure there will be no interference with the use of the car park. Users of the car park should continue to utilize the usual payment options, including the Easy Park device. As you will note, this debacle, when it came to my attention in January, was one of the reasons why the current stewardship order was put in place. In short, the Cabinet and I have serious concerns about the way in which the corporation finalized the arrangements that has led to this occurrence. As steward, I will endeavor to keep the public updated if and when circumstances change. The public can be assured that the Corporation of Hamilton are exploring all legal avenues to find a solution to this matter and will continue to work with the joint receivers. Thank you very much. I'm happy to take questions.